Good morning. Our video today involves search incident to an arrest. When we talk about search incident to arrest, there are three areas that we're basically going to deal with. First, search incident to an arrest, and when we're talking about the spatial area or the grab area, that area from which the suspect can grab evidence of a crime or a weapon. And then the second phase of search incident to an arrest or search that is incident to arrest is that which is controlled by U.S. versus Robinson, and that's the search of the person of the arrestee. The third, we're going to talk about an extension of the first one, which is the search of the spatial area, which is controlled by U.S. versus Chamel or California versus Chamel. And that's going to be the search of a car, the search of an automobile, incident to an arrest of occupant of the automobile. And so we're going to start with Chamel versus California, which is, as I said, deals with the spatial area, the area in which the police officer can search after making an arrest of an individual. Remember, these all are preceded by an arrest, or these all are based upon an arrest. So we start with Chamel versus California. In Chamel versus California, police officers arrived at the home of Mr. Chamel with an arrest warrant for him for burglary of a corn shop. Uh, police, Mr. Chamel's wife let the police officers in, and they waited 10 or 15 minutes for his arrival. They got to the house while Mr. Chamel was at work, and they waited for Mr. Chamel to come to the house. And when he came to the house, they arrested him. Very interesting to me because they knew where he worked, and they could have served the arrest warrant on him while at where he worked. But it's obvious that police officers wanted to search his home as well, and therefore they waited until he came home. And so the question became, they arrested him at his home, and the question became whether they could search the spatial area, the area in which they had arrested him. And the court said, incident to an arrest, it is reasonable for arresting officers to search the suspect to remove any weapons or to seize any evidence on the arrestee's person. There is also justification for a search of the arrestee's person and the area within his immediate control. The area within his immediate control. This is generally called the grab area. This area within his immediate control best can be explained as the area from which the person can launch and grab destructible evidence, or he can grab a weapon. Reading it again, there's also justification for search of the arrestee's person and the area which is in his immediate control, construing that phrase to mean the area from which he might gain possession of a weapon or destructible evidence. There is no comparable justification, however, for routinely searching in a room other than that at which the arrest occurs. Again, the spatial area, that area from which the arrestee can launch for the purposes of attaining destructible evidence or a weapon that can be used against the officer. They cannot go from room to room in order to search. They can only search that spatial area, that limited spatial area. The scope of the search incident to an arrest is limited to the person of the arrestee in a grabbable space around him from which he could reach weapons or evidence. The search must occur at the time of the arrest, the first requirement. The search must occur at the time of the arrest. That is, it must be contemporaneous with the arrest. However, generally the arrest occurs first, and then there's a search of the spatial area incident to an arrest. However, the arrest does not have to occur first. But the search cannot initiate the arrest. The arrest has to initiate the search. That is, we can search first. The officers can search first if there is an indication that the person may be dangerous, if there's an indication that the person will have access to evidence that is destructible. But the officer, at the time that he searches, already has probable cause for the arrest. And so he has probable cause for the arrest, but he conducts the search first. That's going to be considered a spatial search incident to an arrest, because the arrest is not based upon evidence that's been gained from the search, but the search is based upon the probable cause that the officers have for the arrest. Once the subject is securely in custody and the immediate exigency of the arrest situation disappears, so does the excuse for circumventing the warrant process. Thus, a search has been deemed incident to an arrest only if it was substantially contemporaneous. Only if it was substantially contemporaneous. Contemporaneous. Underline that. Write that phrase down. Very important phrase. With it, and was confined to the immediate vicinity of the arrest. So basically what we have, officer makes an arrest, the officer can search the grab area. Now the question becomes, again, very interesting, what is the grab area? What is the grab area? The officer has the right to search regardless of whether the arrestee can grab or not. He cannot go into rooms, other rooms, or remote areas. Let's assume that the arrestee is arrested in the kitchen. Now, where can he search in the kitchen? He's there. He's at the table. He's playing cards with some of his buddies. They come in with the arrest warrant into his home, and they arrest him in the kitchen. Now, in order to effectuate the arrest, we know that Summers versus Michigan, or Michigan versus Summers, allows them to take them out of the room. They can take the suspect out of the room and take him into the living room. Now, once they take him out of the kitchen into the living room, can they also search the living room? The answer is no. They can search the kitchen, and they can go back to search the kitchen even after they've moved him from the living room, because at the time of the arrest, the evidence was grabbable within his grab, within his lunch area, and also he could have gained a weapon to use against the officers. So the officers can move him and then go back, and they can actually search that area. They can search that area in which they arrested him. That means they can search the area immediately around him, and if there are cabinets within his area, within his grab space, they can search the cabinets, inside of the cabinets, again for the purposes of destructible evidence or a weapon that could have been used against the officers. And it goes on. A search is deemed incident to arrest only if substantial contemporaneous and confined to immediate vicinity of the arrest, as we said. The search may precede the arrest, and we've said this before. If there's probable cause for the arrest, the search cannot establish probable cause for the arrest. Now, there was a case, and the question became U.S. versus Lucas. Does it matter if the arrestee is handcuffed and incapable of reaching the area searched? It does not matter. It does not matter that they handcuffed him, take him away, and again take him to the next room, and he can't reach the area. It was within his grab space at the time that he was arrested. And this is based upon at the time that the person is arrested, not what happens immediately after the arrest. Now, I can't go too long. One case, U.S. versus Edwards, they actually arrested a suspect for some break-ins. And they could have conducted a search incident to an arrest at the time that they arrested him, but immediately they took him to the station, they booked him, and after booking him, they went back to the department where they arrested him, and they searched the area. U.S. versus Edwards says that is permissible. The court concluded that the search or seizure that could have been made on the spot at the time of arrest may legally be conducted later when the accused arrives at the place of detention. Further, the normal process incident to arrest and custody has not been completed when the suspect was placed in his cell. Therefore, if the officers believe that there was probable cause to search at the time, or they could have searched at the time that they made the arrest, and that area could have been searched, they can go back and search that particular area, even though it's later and they've taken a person to jail, according to U.S. versus Edwards. Another interesting case dealing with the grab area is Washington versus Chrisman. In Washington versus Chrisman, officers suspected a young man of being a minor who was drinking, a minor in possession of liquor. And so they suspected that he was a minor, and they accosted him. And it was outside of, he was a college student. He was outside of his dorm room. I think maybe he was at a county fair somewhere. But anyway, they accosted him in an area, and they, again, suspected him being a minor in possession of alcohol. And he says, hold it, no, I'm not a minor, that I'm a college student, and I actually am of age, but I don't have my ID on me. Now, if you allow me to go back to my dorm room, I will show you that I have an ID and I'm not a minor in possession. And the officer allowed him to go back to his dorm room for the purposes of showing the officer that he did not have, that he was not a minor. And so he placed him under arrest before he entered his room. He placed him under arrest, but it seems as if the officer told him that if you can show me that you are not a minor, and then I will let you go. But he actually placed him under arrest before he went into the dorm room. Now, the suspect walked the officer into the dorm room. When he walks him into the dorm room, what happens? His roommate is there smoking drugs. His roommate is there using drugs. And so the officer arrests him for, arrests the roommate at that particular time for drug use, and then officer search. And he searches incident to an arrest in order to find other drugs. And so the question became whether the officer created a grab area, whether he created a grab area. Officer cannot create a grab area. They can't move you from room to room. They can't move you from place to place in order to be able to search and say that it's a search incident to an arrest. However, here the court said that the officer had the right to be at the elbow of the arrestee at all times. It was the arrestee who was moving. It was the arrestee who decided that, look, I can show you that I'm not a minor in possession, that I am of age. And so the officer was going to permit him to do it. But at the time he was arrested, and again, the officer has the right to be at the elbow of the arrestee at all times. And if the arrestee moves, officer moves. And if incidental to that, the officer finds evidence of another crime, or the officer finds evidence that the arrestee is fabricating, then that evidence can be used against the arrestee. The court reasoned that once the officer placed the suspect under arrest before returning to the suspect's room, the officer had a right to remain literally at the suspect's elbow at all times. The absence of an affirmative indication that an arrested person might have a weapon available or might attempt to escape does not diminish the arresting officer's authority to maintain control over the arrested person. He has a right to maintain control over the arrested person. Every arrest must be presumed to present a risk of danger to the arresting officer because there's no way for the officer to predict reliably how a particular suspect will react to arrest or the degree of potential danger. Let's move on. Let's move on to the next one. And so we've dealt with search incident to an arrest, a spatial area. Now let's look at a search incident to an arrest of the person. The search incident to arrest, before I move on to the search incident to an arrest of a person, the search incident to an arrest, the Shimel search, we call it, the Schimmel, some people call it. And you should remember the terminology because it defines the particular search, that spatial search, that search of that grab area. So the Shimel search, or the Schimmel search, is a look at the totality of the circumstances. It's a case-by-case type analysis. That is, in order for that search to be conducted, you must show one of two things. It must be shown that the person has access to destructible evidence, or the person has access to a weapon that can be used against the officers. And so the purpose is to prevent the destruction of evidence or the safety of the officer. And one of those two must exist in order to show that there is grounds for the search incident to an arrest of the spatial area. Now let's look at the search of the person, of the arrestee. Defendant was stopped for driving in United States versus Robinson under revocation. The crime carried a penalty of jail, fine, or both. Defendant was stopped, placed under arrest, and searched. Officer patted down Robinson and felt something he could not identify. The officer reached in and pulled out the object, which turned out to be a crumpled cigarette package. Officer felt package and could not determine what was the contents of the package. He opened it and he found heroin. Now let's take a look at it. Officer arrests a person. He arrests a person and he pats him down. He pats him down. He feels something that he can't identify, and he prods it and he feels that he still can't identify it. So he reaches into his inner coat and he takes the object out. Not only does he take the object out, he inspects the object and he finds something inside of the object. Robinson says, hold it, you've gone too far. There was no indication of danger. He felt it. It did not feel as if it was a dangerous weapon. And there was no reason that you believe that it's destructible evidence because you arrested me for a traffic violation. And there's no destructible evidence that could be found on my person inside of a package such that would deal with the purpose of the arrest, or why you arrested me. However, the court said that a search of the arrestee incident to an arrest is a full-blown arrest search. That is, you can search the arrestee and you can search his person. And it's not a Terry search. It's not a pat down for a weapon. The reason they explain it is that once an arrest occurs, it's not a cursory outer pat down. This is, or is not an investigatory procedure where he's investigating crime, the officer's investigating crime, but it's actually he has arrested, he's confining the person, and confining the person is a close contact, and just the tenor of an arrest is a heightened type atmosphere. It's an incendiary atmosphere, and thus the officer has the right to search that person to make certain that that person doesn't have a weapon, and thus they developed that bright line rule, a per se test, that a search incident to an arrest of the person is a full-blown search of a person inside of his jacket, inside of his pockets, and also inside of any containers that he may have on him. That is, he can go into the cigarette package even though he cannot identify, or it's not readily identifiable as a weapon. He can go into the package and for the purposes of searching or completing the search incident to an arrest. And the case basically says that the authority to search the person incident to a lawful custodial arrest, while based upon the need to disarm or discover evidence, does not depend on what a court may later decide was a probability in a particular arrest situation that weapons or evidence would in fact be found upon the person of the arrest. A custodial arrest of a suspect based on probable cause is a reasonable intrusion under the Fourth Amendment. That intrusion being lawful, a search incident to an arrest requires no additional justification. He could search the person. Officer stops a person. He has probable cause for an arrest. He makes an arrest. He can search him. He can search him. He can search objects that are also within his presence, or objects that also that are on him, or that are immediately within his presence. This became an issue in the case. If you look at the search incident to an arrest, the search of the person incident to arrest, in Knowles versus Iowa. In Knowles versus Iowa, the person was stopped. He was stopped for a traffic violation, and it was an arrestable offense. However, the person was not arrested. He was not arrested. He could have been arrested, but he was not arrested in Knowles versus Iowa. The court said even though it was an arrestable offense, that a search incident to arrest must occur contemporaneous with an arrest. And therefore, the search of Knowles' car, or the search of Knowles himself, was a violation of the Fourth Amendment because an arrest did not occur. So a search incident to an arrest requires an arrest. It doesn't matter that it is an arrestable offense, and the officer could have chosen to arrest you, but he gave you a citation. If he only gives you a citation and then search, that's violates the Fourth Amendment, because it's not a search incident to a probable cause arrest. Another case, Chadwick, which we're going to come back to a little later. Chadwick case, U.S. versus Chadwick. They arrested a person, and he had luggage with him. And they took the luggage, and they could have searched the luggage. Matter of fact, there was a footlocker. They could have searched the footlocker at the time of the arrest. However, they took the footlocker, and they took it down to the station. And 90 minutes after the arrest, they searched the footlocker. And they argued that this is a search incident to an arrest because it was on his person. And incident to an arrest, anything that's on that person's person or within his possession, we can search it. However, the court said the 90-minute gap was too long, that it was not a search incident to an arrest, that there was no indication that there would have been a danger to the officers, or that he could destroy evidence. And it appears that what the court did here with Chadwick is that it gave a heightened degree of protection for luggage. That if there's luggage, the luggage has to be searched contemporaneous, that they cannot come back and search the luggage. And 90 minutes later, they cannot come back and search the container. A very interesting case also that followed Robinson was Atwater versus the City of Lago Vista. In Atwater versus the City of Lago Vista, um, a lady had been involved in a traffic violation. As a matter of fact, the traffic violation was uh, failure to secure her children properly while she was driving. That is, to place safety belts on the children, to place children in car seats. And the officer had seen the woman before and had an encounter with the woman. He stopped the woman again, and when he stopped her, he indicated, "I've seen you before," and it appears that you're not changing or you're not doing anything different. The officer stopped her, and not wearing a seatbelt in a jurisdiction in Lago Vista, California, was an arrestable offense. The officer stopped her and he arrested her. He arrested her for something, a very minor offense that generally a fine is given or a citation is given. But he decided that he was going to arrest her. And it appears that his arrest was based upon the fact, or some animus that he may have had, and based on the fact that he had encountered this woman before, and it just kind of irritated him. The fact that she was not following the law. And so he arrested her for something that, again, probably had never been someone had been arrested for, and it's a seatbelt violation. The interesting thing was that when he stopped her, she had her children with her, and she began to ask, "Can I call somebody to get my children?" And the officer was very adamant. "No, you can't. You can't call anybody to get your children. Can't take your children home." But eventually, he allowed someone to call. She allowed her to call someone. Someone did come and get the children. And so the question became, could he actually search her, or was a proper arrest? And they said that yes. The court said even an officer, if an officer has probable cause to believe that an individual has committed even a very minor criminal offense and is present, he may, without violating the Fourth Amendment, arrest the offender. Atwater's arrest satisfied the constitutional requirement. Officer had probable cause to believe that Atwater had committed a crime in his presence. He had committed a crime in his presence. Thus, he could arrest her. The problem with this is that for a minor violation that generally receives a citation, if the statute says that the officer can also arrest, even though it's not the intention of the statute that the officer arrests every time there's a seatbelt violation, but an officer can arrest as a result of seatbelt violation, that arrest is proper. What's the problem? That arrest can lead to a search. That arrest can lead to a search of the person, and here that arrest could have led to a search of a car. And it became a per se rule. O'Connor wrote a dissent, a very scathing and a very touching, a very good dissent. She said the per se rule the court creates has potentially serious consequences. When a police officer has probable cause to believe that a fine-only misdemeanor has occurred, the officer may stop the suspect, issue a citation, and let this person go on their way. Or if a traffic violation, the officer may stop the car, arrest the person, search the car, search the entire passenger compartment, including purse or packages, and impound the car and inventory all of its contents. The majority gives officers unfettered discretion to choose that course without articulating a single reason why such action is appropriate. O'Connor is saying that we've gone too far. That again, a search incident to arrest opens up a panoply of things that can be done by the officer. And here, this officer could have done several things, and we've created a per se rule that officers can use to go as far as they want to go. Now we're going to stop there, and I'm going to pick up with search of a vehicle incident to arrest of occupant. Thank you very much, and we'll post this video.